McCarrell versus Hoffman Roche. May we please have appearances of counsel?
Good morning, Your Honors. David Buchanan, Petitioner of McCarrell.
Good morning, Your Honors. Christopher Placatello on behalf of Amicus, New Jersey Association.
Good morning, Your Honors. Paul Schmidt, President Berlin on behalf of Roche, with my colleague Adam Mandel.
Good morning. My name is David Scott. I'm the lawyer for the United States.
Good morning, counsel, and welcome. Mr. Buchanan, you may proceed.
Good morning, and may it please the court, counsel. If I may, Your Honor, I'd just like to reserve a brief time for rebuttal.
That's fine.
Thank you. We're here today, I guess several months after the appellate division reversed course, specifically in Mr. McCarrell's case, but also more generally with regard to choice of law determinations and statute of limitations. Not with regard to the standard it articulated, but with how it applied that standard to the facts in Mr. McCarrell's case. This case has a bit of a long history. It was filed in 2003. It was filed 60 days after Mr. McCarrell discovered that he developed ulcerative colitis as a result of his Accutane use. Filed it here in New Jersey, availed themselves of the New Jersey statute of limitations, consistent with the then guiding precedent at that time, which would have been Gante's. The case was litigated through the first trial. Following a Lopez hearing, the court concluded that he was reasonably unaware of any connection more than 2 years prior to the time that he filed suit. The court applied New Jersey law, found it timely, and tried the case. Mr. McCarrell prevailed at trial. It was appealed in a very lengthy opinion from the appellate division, which was unpublished, like 112 pages or so. The appellate division affirmed on all legal issues but one, an evidentiary point, and affirmed specifically on the trial court's choice of law determination. It was remanded for a new trial. In the intervening time in and around the argument before and after, there's a lot in the papers on this. I won't restate too much of it. PV versus Camp JC came down. Justice Long's decision, which framed choice of law as a general matter under the restatement second. No new issue was raised before the retrial. Mr. McCarrell again tried the case. He received a substantial verdict, more substantial verdict than the first time. Subsequent to post-trial briefing, the defendants raised the choice of law issue on statute of limitations anew, and it was considered by the trial court following the trial, following the post-trial briefing, and in the phase prior to the ruling on the JNOV motion. The court concluded first, law of the case precluded consideration or reconsideration of the appellate division's determination. Secondly, determined that even if the court had to consider that new case in PV versus Camp JC's, that under that interest analysis, under that contact analysis, and under the framework of restatement second, Mr. McCarrell's case was still properly considered under New Jersey law with the relevant interests and contacts at stake in that case. It was appealed thereafter on a few issues, but this was the issue the appellate division took up. Following the Cornett decision, the appellate division concluded there had been a change. I think the appellate division noted that it was a seminal case in PV versus Camp JC. It doesn't call Cornett that. A seminal case that warranted the court's reconsideration of the issue. The court reconsidered and then purported to apply the Cornett test. We're here, I think, first because we take exception to the way the trial court applied the Cornett application of 145 and 146. More generally, and as a bigger picture for New Jersey, it is very important that litigants get good guidance as to the statute of limitations question at the outset. When Mr. McCarrell filed his case, there was fairly clear guidance and fairly clear, I'd say, clarity as to New Jersey's interest in, frankly, deterrence. New Jersey's interest when there was real contacts, and not forum shopping contacts, not when somebody was conveniently bringing a defendant into a case to avail themselves of some contact with New Jersey. But when there was real contact with New Jersey, when there was a manufacturer in New Jersey had a deterrent interest, and it enforced that deterrent interest by extending its statute of limitations. That was true in Gante's, that was true in Marshall, that was true in the appellate division decision in Smith v. Alza. I'd submit This case, Mr. McCarrell's case in the appellate division, is the greatest exception to New Jersey's extension or not of a statute of limitations, given the qualitative and quantitative context here. This is not a situation, as was the case in Cornett, where the plaintiff there named a New Jersey parent when the real case was against a Florida subsidiary. In Cornett, the manufacturer of the product, the manufacturer who developed, marketed, sold, promoted the product that ultimately caused the Kentucky resident's injury, was from Florida. A New Jersey parent, J&J, was named, and the court then did a 145 and 146 analysis. And I don't think you'd have any difference under Gantes. I don't think you'd have any difference under Heavner. I don't think you'd have any difference in this court's precedent with that result when there are slender ties to New Jersey. This court has been fairly consistent, fairly protective, frankly, when it looks like gamesmanship. When it looks like somebody is coming into this court, naming a defendant conveniently, manufacturing allegations to try and create a, quote, greater interest around something, to give the state an interest when it doesn't. And the courts have called it. Frankly, you can look at the case law and you can look at the doctrines around it, whether it's restatement first, whether it's restatement second, or whether it's something in between, governmental interests and Gantes and other things. But the court is essentially looking to see, do we really have an interest here? Is this defendant, is this conduct something that we should be engaged in?
So before we get to that question, tell us what the appropriate framework to apply is. Specifically, should this court embrace Section 142?
The court should embrace 142.
Tell us why.
It begins at the top with, that is the statute of limitations section of restatement second. When you read PV versus Camp JC, there's the history of the restatement evolution by Justice Long, going through the scholarly articles talking about how we got to where we got to, and the criticisms of the restatement first, and where New Jersey peeled off. New Jersey parted company with restatement first. And then restatement second came along, and more specifically as it relates to the statute of limitations, was amended in 1988. I'm sorry, the restatement second, 142, was amended in 1988 to account for this court's precedent. It mirrors the language, it mirrors the court's decision, and it's cited in the commentary and the reporter notes, the Hoffman decision from 1971.
But if we follow 142 as you suggest, isn't there a tension between the starting point in that analysis, which is the law of the forum, versus the starting point presumptively in the Camp JC analysis, which is the place of injury, and then we analyze from that point
They are
forward.
incongruent. They start in a different place. The presumption in 142 is, I'd submit, the right presumption, because
Why?
the court controls its docket. The court has that concern, a parochial concern. This court, the Alabama court, a Texas court, they have their own concerns with docket management.
Doesn't it
For
go,
a presumption,
doesn't it go further than that? If you look historically, if you look at the commentary to 142, statute of limitations in the common law was considered a matter that the forum should decide. And it was only through the evolution of the restatement process that the first governmental interest, substantial interest developed. So the difference, as I see it, between Camp JC is Camp JC was applying the restatement, but if you went back to the common law, the place of injury is where the substantive law would apply. And if you go to, and that's why the presumption is there. And if you go to the common law with respect to the statute of limitations, it was considered procedurally, and that was considered what the forum would do. And that's, from my view, why the restatement has placed the presumption in different places. Am I wrong about that?
I think you're correct in how it's evolved, Your Honor. And there's no question that that is how we got here. I mean, there was a lex loci, or loci, doctrine as it related to substantive law, and as it related to statute of limitations, they were traditionally viewed as procedural. This court parted company with that view in Hoffman in the early 70s. But there is a reason for it, I think, that's beyond just tradition. There's a situation, if you're in a 145 or 146 framework, this court is presumptively assuming the statutes of limitations of Florida, at 4 years, of Minnesota at 6 years, of other states that have more lengthy or shorter, I mean, that's the presumption, running with the substantive law. And it does take this court's right or this state's right to control its dockets consistent with its policies, the legislative policies embedded in the statute of limitations.
But wouldn't it be consistent with our approach under Camp JC to allow the statute of limitations call to follow the substantive law call?
If you were treating statute of limitations as substantive, then yes, it would be consistent. I don't think, when you look at Hoffman rejected that as it related to statute of limitations. Hoffman said, we do not go there. There was an invitation, there was scholarly commentary about having statute of limitations follow the forum law, and it appears the court was concerned about just such a result, having statutes of limitations imposed on the court from outside where it doesn't have the ability to control.
Historically, the courts have always made the difference between the two, the lex loci and the statute of limitations. And the same distinction is now made in Section 145 and Section 142, except it's the starting points. You have substantial interest. The starting point just changes. So the presumption is the statute of limitations will apply to the forum state unless one of those two subparagraphs apply. And
that is the framework, Your Honor. That is the framework, and yes, and I believe it originated from those traditions, and I think those traditions, as I said, I think were also tied to the practical issues of courts.
And Mr. Buchanan, we follow an issue-by-issue approach. And when we're considering, as we are here, an Alabama situation that doesn't allow for discovery tolling, and New Jersey, which does, we seem to have an actual conflict that is going to an issue that takes on a substantive nature. So again, I'm going to come back to you. Why would we not follow an issue analysis that's following the same kind of analysis we would for other substantive issues?
Your Honor, it appears that is a discussion that seems to be in the literature by scholars, legal scholars, and conflict scholars for 100 years about whether the remedy or whether statute of limitations is tied to the remedy or to the right. Mm-hmm. And people have criticized it as being artificial, but there are still some practical implications, I believe, to maintaining the different starting presumptions, one versus the other. And I should pause. We're talking about what I think is, and what we maintain is wise. I don't think it makes a difference in the outcome in Mr. McCarrell's case. It certainly makes it more straightforward under 142, but I don't think it disposes of it, certainly not in the manner that the appellate division did.
Can you tell us why?
I'm sorry.
I was interested in following up, but if you have another question, just as
certainly. So under 142, and it's 142, and we've been talking about 142.2. There's also 142.1. 142.1 says that our statute of limitations, if it bars a claim, bars it. Period. So if we have a 2-year statute of limitations, and there's a 4-year in Florida, there's a 6-year in Minnesota, there's a 3-year somewhere else, under Section 1, our statute of limitations, because that reflects our legislative policy, that reflects or our judicial policy, depending on what state's adopting it, that applies, and we close our doors on the absent exceptional circumstances. There's escape hatches, as Your Honors know, in the restatement.
We probably won't be seeing too many of those cases. If lawyers understand the rules in advance, they're not going to be filing here.
You're right, Your Honor, and that's very important here. I think for Mr. McCarrell's sake, and I feel like we've been a little bit on shifting sands and trying to understand exactly how that would play out. Gante's, I thought, was clear, and I know when I was litigating in the early 2000s, I didn't file Mr. McCarrell's case with my office. I wasn't a part of that discussion, but I was filing other cases and certainly aware of Gante's and the belief that New Jersey had a strong interest in deterrence as it related to New Jersey-based conduct. Not coincidental conduct, not just principal place of business conduct, but you're real and you're here and you're doing things here. And unfortunately, a mishap happened and it caused a lot of harm. And that happens. And that happens to New Jersey companies. It happens to drug companies in Boston and in Philly and in California. It happens to other companies. But New Jersey had that interest. I think New Jersey still has that interest. It hasn't gone away. There still is a deterrent interest that needs to be respected. Mm-hmm. But now we have the additional gloss, obviously, of Section 6 and some other considerations to go into the mix.
What do you make of the fact that when Gantes was decided, in many cases we're considering statute of limitations, an analysis under 142 never came up?
You know, I'm guilty of this in this case. This is a wisdom later learned is better than wisdom never learned situation.
Mm-hmm.
I don't know. I don't know why it didn't come up in Gantes. I don't know why it didn't come up in Cornett. I've checked the briefs in Cornett before the Supreme Court. This Supreme Court wasn't guided by any argument or any presentation on 142.
Mm-hmm.
Why didn't it come up before the appellate division in this case in light of the Pidcock decision? You had a very nicely written opinion by Judge Skillman.
A beautifully written decision, and that's what I was alluding to, Your Honor, when I said wisdom later learned is better than never learned on our part. We certainly identified 142 in our opposition papers, but it was not a feature. It was basically a moreover. 142, the result under 142, does not lead to a different result than you'd get under 145 and 146 here.
You touched on some of the practical implications of adopting Section 142. Can you speak to the risk of forum shopping as a result?
Yeah, you know, anticipating this argument, I've been trying to think of that, because the forum shop here would be to avail yourselves of the discovery rule, I suppose. I think there's 4 states that don't have a discovery rule. So that's not a big forum shop.
Well, I'm trying to understand this. Typically, forum shopping has never been considered filing a suit in the state where the defendant is domiciled, incorporated, manufactures the product, and markets the product. I mean, forum shopping traditionally has been looking for some other unfavorable jurisdiction unconnected to the defendant. This is the defendant's home, where the defendant did everything in this case.
Justice,
well, like, why would that be considered forum shopping?
It's not improper forum shopping. I think the distinction drawn by Justice Handler and Gantes is forum shopping we have a concern about, and that which we don't.
Typically, a defendant, you would think, would rather be sued in its state rather than in a foreign state.
Well, when we tried this case, 6 of the 7 Roche witnesses were from New Jersey.
Well,
and that's where the proofs came from.
No one's questioning whether there's jurisdiction. It's a question of which choice of law applies, correct?
They are separate issues. I think it informs the deterrence aspect when not only is the company here, that it's not coincidentally here. This isn't a situation where they just got tapped passing through. This is a situation where they designed, promoted, regulated, communicated from. If you picked up the label, when Andy McCarrell picked it up in 1995, it would have said, call Roche in Nutley, New Jersey if you have a problem.
Well, the forum makes under Section 142, the forum makes a difference. Because the presumption applies to the forum state, correct?
That's
so
right.
Whether or not you file...
Where you initiate the case.
Exactly.
Mm-hmm.
Because the forum presumptively gets the benefit of its statute of limitations unless those other factors counsel against it, correct?
I agree, Your Honor. And you know, this court's not alone in looking at 142 as a restatement second jurisdiction, as New Jersey seems to be or be developing in that direction. This is the way Massachusetts works. We cited the case, a recent case, in Ray Fresenius Products Liability Litigation. In that case, the court applied, 142-2, identified the substantial interest, and again, identified the 2 parts of 142 conjunctively.
Is there a uniformity argument? Because suits such as this are going to come from plaintiffs throughout the country. And those plaintiffs will probably be similarly situated to your client. And the question is whether or not you would be using 50 different statutes of limitations as opposed to the statute of limitations that applies in the very state where the defendant is situated.
It's an underlying principle when you read through those comments and notes to the restatements and the commentary around it. They are hoping that courts broadly adopt these same principles, because that will then provide what I believe is the ideal uniformity in the application of choice of law. The restatement second after the 1988 amendments is advocating getting rid of borrowing statutes because of unforeseen problems with borrowing statutes, and going to this more flexible analysis that at least starts with the presumption and then has considerations that allow it to move to consider appropriate cases. But to your Honor's point, there's a big state coordinated proceeding. New Jersey is not the only state that has coordinated mass tort proceedings. We have them. Massachusetts has a substantial number of them. They're in Illinois, they're in California, they're in Pennsylvania, because sometimes things go bad and there's convenience to bringing everybody together and doing it with efficiency. Now, in Massachusetts, when this happened, and I represent New Jersey people in Massachusetts, Massachusetts extended their more favorable statute of limitations to our residents. So on a 142 analysis. So
That goes to interstate comedy too. Will we treat out-of-state residents the way we would treat our own residents?
Agreed. It's a Section 6 consideration. It's relevant here. And the more consistent the states get in that regard, the more consistency litigants have not only within state but without.
Questions?
No.
Anything else you'd like to add?
No, Your Honor. Thank you.
Thank you. Mr. Placatello. And I'm going to invite amici on both sides to feel comfortable adopting arguments that have been presented before you stand up. Please go ahead.
Good morning, Your Honors. Thank you for allowing me to speak. It's a privilege to be here. If we altered the facts of Mr. McCarrell's case just slightly, I think it might bring the issues into a little bit more clarity. Suppose Andrew McCarrell took the Accutane in Florida and started to feel ill there, and then moved to Alabama, and then had his medical treatment in the town next door in Mississippi. Well, in Florida we have a 4-year statute of limitations. In Mississippi, we have a 3-year statute of limitations. Alabama, we do not get the benefit of the discovery rule. And he decides that he's going to bring his case in New Jersey. Under that set of facts, what statute of limitations should presumptively apply? I mean, it's conceivable. It happens all the time. And I submit that Section 142 strikes the proper balance and gives the proper guidance to courts when dealing with these issues. So in my example, if you apply Section 142, the plaintiff does not get the benefit of the Mississippi 3-year statute or the Florida 4-year statute, but does get the benefit of the New Jersey statute unless a presumption can be overcome by the defendants. So to answer the question posed early, what policy reason is there to apply Section 142 versus 146? And I would submit that the issues that you're trying to address with statute of limitations are different, and that's why the courts say take these on issue by issue analysis. 142 actually protects New Jersey companies in the majority of cases. It's interesting. I think I could probably argue their appeal under a different set of facts, right? Because 142 says that if you're coming from Mississippi or Wisconsin or Minnesota with a 6-year statute and you come to New Jersey to file a case, you only get the benefit of a 2-year statute. It actually protects our company, our corporations, and it gives guidance so that the corporations know that if they're going to be sued here, this is what the rules are. And the plaintiffs know, if they come, what the rules are going to be. And it also carries out the legislature's intent, which is stale claims. We consider claims stale after 2 years. And it does other things. It helps us with the administration in our courts, consistent with what the legislature envisioned. You can take Atlantic County. There are thousands of Accutane cases. Under the current regimen, Judge Johnson is required to do an analysis, theoretically, of 50 different state laws on statute of limitations. From an administration point of view, that's a nightmare. Where if the presumption was, where it should be under 142, that determination in a multi-county context would be made early, up front, and everyone would be guided. And if you apply 142, we're actually taking advantage of the experience of our trial courts. Our trial courts know how to deal with statute of limitations issues. They know how to deal with Lopez hearings. What happens if you just run with 145 in the special interest, in the most significant interest? What is going to happen? So a Mississippi plaintiff doesn't get a Lopez hearing. That's a jury determination. But a New Jersey plaintiff, you do have a Lopez hearing. So it really makes sense for everyone.
Counsel, does the compelling nature of your argument draw strength from the fact that we're dealing with a products liability case with a pharmaceutical corporate defendant located in New Jersey? And would it lose some of its compelling nature if we were talking about an individual defendant involved in a more common negligence action where the injury and interaction between the two people, the plaintiff and the defendant, did take place out of state?
Well, I think then it's just as simple. Because if there's a thin reed to be here, then presumably the out-of-state statute of limitations would apply. But, you know, the defense...
Isn't the starting reed the same point, though? I mean, the defendant is physically a resident of New Jersey, and
right.
You have every right to sue that individual here in our courts.
But it's very interesting when you look at it. So, for example, you could look at Coronet, Hefner, and the Pitcock case, where 142 was applied in Pitcock. But I submit to you, if you would have applied 142 to the Coronet state of facts or the Hefner state of facts, you would have applied the foreign jurisdiction statute of limitations, because New Jersey had no substantial or no real interest in applying its statute of limitations. And it's interesting in Coronet, because while I might not have agreed with how we got there, because I think analytically I didn't agree with it as a plaintiff's lawyer, the result would have been correct. Because if you would have used a 142 analysis and you looked at a Florida company who manufactured the product and marketed the product, no doubt most courts, I believe, would have arrived at a foreign statute of limitations applying, not New Jersey, because Johnson & Johnson was only sued here because they were the parent here.
So you think, from a policy perspective, it makes sense to use the 142 analysis in all tort actions as opposed to our Camp JC approach for substantive issues where we follow the location of the injury presumptively?
And I think it does for all the reasons I've stated. And I can envision many circumstances where that's not necessarily favorable to the plaintiff, but it's consistent. It's predictable. Everyone knows what the rules are. We don't have courts, handling multi-county litigations, trying to do analysis of 50 different states on a statute, whether they should be there or not. And the issue of forum shopping, because the issue was raised, I would say that's a red herring here. When more than half of the states have statute of limitations that are more liberal than ours, is that really a concern? And should it be a concern? Because this court in Gantes made clear when that issue came up that, as long as there's a legitimate basis to be here, that's not forum shopping. This is not a slender tie. The McCarrell case is not the slender tie that should concern a court and did concern the court in its analysis and Gantes. And it's also interesting that the defense, and I never got a chance to address this, said that the Product Liability Act somehow should impact, and it shows some kind of preference for protecting, pharmaceutical companies. But that was also rejected outright in Gantes. The court in Gantes, absolutely said that the Product Liability Act was never meant to address that. The legislature could have if it wanted to, and the Product Liability Act just doesn't apply to pharmaceutical cases. It applies to all kinds of products, and Gantes was very clear, and it said that because the legislature did not do something special for product cases, there's no reason to treat them different than regular cases. So at the end of the day, when you look at what is the most fair way to do this, what's the most predictable way, not always in the plaintiff's favor. As I said, I think I could rise under a different set of facts and argue 142 protects the defense in a significant number of cases.
Well, let's take that one.
Right.
You mentioned like Wisconsin.
Right.
If Wisconsin has the longest statute of limitations,
Right.
and the person takes the product there, they're going to file probably in Wisconsin if they're out of time in New Jersey. I mean, let's face it, there's a certain amount of strategic calculation going on.
I think that that's true, but there are reasons why plaintiffs file cases in New Jersey other than the statute of limitations. They file it because they think the substantive law for some reason might be in their favor. They might think that the treatment of experts is more fair than it is in other places. They might think our courts are just better able to handle these cases and our judges are more competent, something I believe, than they are in other places, and that they are going to get a fair shake in New Jersey.
How about the expectations of the defendant? Can we say that their expectations of not getting a fair deal is less persuasive when they're sued in their own state where they've manufactured the product and marketed the product? It's more difficult to argue that their reasonable expectations have been violated, no?
No, I agree with that entirely. And that's why I said I'm almost surprised at the positions that are taken here, because predictability is what any defendant wants. And they get that here. If somebody's going to come here and sue them in their backyard, they know what the law will be. So I guess unless there are other questions.
I have one last question.
Sure.
If we were to adopt Section 142, do you think the court would have to modify or overrule its analysis in Camp JC or Cornett in any way?
Not at all. I believe that Camp JC is a logical extension of Gantes, that's where the law related to liability or tortious conduct lies, and you can have two different starting points. That's the only thing that we're really talking about. I thought it was wise. Would I like the court to modify Coronet just a little bit? Because I think Coronet, to be honest, the court found that there was no conflict, and then applied the foreign jurisdiction's statute of limitations, which is really contrary to Roe and all the other cases that came before from this court. But if the court had Coronet and applied 142, they would have come to the right result for the right reason. I think Coronet, the court came maybe to the right result, but for the wrong reason.
So in Camp JC, we applied Section 145, 146, the restatement.
Yes.
And the restatement obviously has 142.
Yes.
So the drafters of all these restatements think that this is part of a piece. We were only dealing with one piece, I guess, in Camp JC, not the total piece.
That's exactly right. And I think Camp JC was right on the money, as was Gantes. And this issue really has never come up before here. And, there were some very, very smart people who read a lot of cases and a lot of law review articles who had no bias, who came to the conclusion that statute of limitations should be governed by 142 and other and other conflicts for tortious conduct by 146.
Well, there are some people who thought that based on Fu and Ernie versus Marola, that Camp JC was a big step. It took the suggestions in the restatement that had been used to inform New Jersey's conflicts analysis and solidified them into cement in our new test.
Right.
And that was perceived as a bit of a change, as our appellate division has noted in this instance. So this would be actually taking another big step if the court were to adopt the suggestion of 142 and make it our presumptive choice of law analysis for statutes of limitations. Don't you agree?
Yeah, I think it would be a step. It would be an affirmative decision made by the court that, given all the policy reasons that focus on the statute of limitations versus tortious conduct, this is how we're going to handle statute of limitations, and everybody knows what the rules are. So I agree, and I guess I disagree a little bit. I think Camp JC's was really a logical extension of Gante's. I thought it was the right decision. I thought it was an enlightened decision, frankly. I thought it gave people guidance. It doesn't always operate in the plaintiff's favor, but that's not why we're here. We're here to try to come up with the right result. We can focus just on Mr. McCarrell and come to a result, but is that right for all New Jersey citizens and non-New Jersey citizens going forward? And when I say New Jersey citizens, I also mean New Jersey corporations.
Thank you.
So at the end of the day, I really believe that Section 142 strikes a fair balance between protecting New Jersey companies against stale claims, preserves the rights for the wrongfully injured who don't sleep on their rights, and provides predictability and fairness in the administration of justice here in this great state. And I really do appreciate the privilege of being here as amicus. I know you didn't have to permit me to be here, but thank you very much, unless you have any other questions.
Thank you.
Thank you.
Right.
Thank you.
Thank you, Chief Justice.
May it please the court, Paul Schmidt for the Roche respondents. I'll start where we're supposed to start in the choice of law analysis, with the contacts. And there's no dispute in this case that the contacts overwhelmingly favor Alabama, absent some unusual New Jersey interest. That's where Dr. Gerald read the Accutane warning that Roche provided that told her Accutane has been temporally associated with inflammatory bowel disease. That's where she discussed Accutane with Mr. McCarrell, and where Mr. McCarrell was given and had the chance to read the Roche brochure that told him, quote, Accutane may cause the very symptoms he experienced, including rectal bleeding, including diarrhea, including severe abdominal pain. That's where he used Accutane and received those same warnings every time he used Accutane, because they were printed on the packaging for Accutane. And that's where he experienced his symptoms and where he developed his injury. That is 180 degrees away from the hypothetical that was just offered in terms of the contacts. And it was because of those contacts that both sides agree that, absent some unusual New Jersey interest, Alabama law governs the merits deciding issues in this case. That's why the trial court, with plaintiff's agreement, applied Alabama law on every other issue in this case, but for the statute of limitations. This is not a case where the plaintiff filed here because he liked New Jersey substantive law. He filed here to avail himself of his own law on every issue other than the one where it hurt him, the statute of limitations. The question in this appeal is whether the statute of limitations should be analyzed differently than other issues from a choice of law perspective. And this court spoke to that issue 40 years ago in the Heavner decision, where the Heavner decision rejected a different rule for statutes of limitation than it did for other legal issues. And that has been the rule in New Jersey since, most recently 4 years ago in the Cornett decision, where the court endorsed the appellate division's application of Section 146 in this setting to the statute of limitations, recognizing that it requires injury state statute of limitations on facts like these. If the court adheres to Section 146, then New Jersey statute of limitations should apply because the interests don't overcome the presumption in favor of Alabama law, and the court should adhere to Section 146. It fits best with this type of case, a personal injury case. It's consistent with this court's 40-year jurisprudence, started in Heavner and continued up through Cornett. And it's actually consistent with Section 142 itself, which recognizes that in the modern version of 142, which was actually driven by Heavner, 142 is not intended to handle statutes of limitation questions differently than other questions of law. The comments to 142 tell us that. But even the 142 argument falls short in terms of if 142 does apply, because 142 requires a substantial New Jersey interest. And the sole argument in favor of New Jersey having a substantial deterrence interest, a substantial interest in a statute of limitations here, is that New Jersey has a substantial deterrence interest through its statute of limitations and nowhere else in letting this case proceed. And whatever sense there is to that notion in other contexts, it doesn't make sense here, given the Product Liability Act, which tells us what the measure of New Jersey's deterrence interest is. In the Product Liability Act setting, and we're not talking generally about the PLA here, we're talking specifically about the presumption that attaches with FDA approval, which was not at issue in Gantz. It had nothing to do with Gantz. In that setting, New Jersey has decided that its deterrence interest is largely met through FDA regulation, and it makes no sense to disregard that deterrence interest in terms of not applying New Jersey's actual articulation of its deterrence interest. The court here disregarded that deterrence interest, but then say there's some standalone deterrence interest through the statute of limitations. And the court's Roe decision, involving a different legal issue but identical right down to the defendant, choice of law facts, is directly on point. To allow a lifelong Michigan resident who received an FDA-approved drug in Michigan and alleges injuries sustained in Michigan to bypass his own state's law and obtain compensation for his injuries in this state's courts completely undercuts Michigan's interest while overvaluing our true interest in this litigation. That's the Roe decision, 189 New Jersey at 629. Under the PLA, under Roe, under Kendall, applying the PLA in the statute of limitations context, given the basic purpose of the statute of limitations, there's no basis under Section 146 or 142 to say New Jersey has a substantial interest in having only its statute of limitations apply here and nothing else. I appreciate the chance to make those opening comments. My intent was to address in a little more detail why 146 is the right framework and then turn to addressing why even under 142 there's no substantial New Jersey interest.
As you do so, I'd ask you to focus on predictability and uniformity.
Okay. In terms of 146 being the right framework, it does promote predictability. It does promote uniformity in exactly the way that the Heavner decision anticipated 40 years ago by treating statutes of limitation from a choice of law perspective the same as every other issue. It removes the unpredictability of choice of law for statute of limitations being different than every other issue in the case. And it focuses instead on choice of law for every issue being focused on the contacts, focused on the interests, with the same presumption that the home state law, the injury state law, will apply. Section 146 is tailored by the restatement for exactly this factual setting. This issue arises in personal injury cases when you have these facts. An out-of-state defendant sells a product in the state, there's an injury in the state to a plaintiff in that state, and that plaintiff sues. Section 146 is specifically tailored to that factor, to that fact pattern. It provides predictability, it provides uniformity, and the only way...
So what, I mean, if it's so tailored by the drafts of the restatement, why did they also draft 142?
Well, I think it goes to a question Your Honor asked petitioner earlier, which is the origin of 142. The origin of 142 is a historical rule that this court led the nation in abandoning, that the home state statute of limitations always applies.
146 and 142 both have historical derivations from the common law.
Yes.
Lex loci, statute of limitations, and the reason why the presumption is for the place of the injury is because of the common law, and the reason why the drafters of 142 placed the presumption for the statute of limitations, because in the common law, it was the forum state that made that decision, correct?
Yes,
And in Hoffman, all we did was say we're no longer following the common law. We said we would use a governmental interest.
And that's my point, Justice.
And 142 is merely a modification of that. No?
That's my point, Justice Sullivan. 142 hails from a version of the common law that this court rejected 40 years ago, rejected 4 years ago, and has consistently rejected in between. Interestingly, and this is the second point I wanted to make about why 146 is the right framework in this type of case rather than 142, is the modern version of 142 is very clear. It tells us it is not intended to produce the result that petitioner here would have it produce. The commentary to section 142 says again and again, it's not intended to lead to a different analysis than would apply for other choice of law.
So what's your if it doesn't lead to like a different analysis, what's your problem? So we start with the presumption that the forum state statute of limitation applies, and then you have to show that the maintenance of the claim would serve no substantial interest of the forum. And in doing that, you have to now argue that New Jersey has no interest in regulating pharmaceuticals or manufacturers in this state, has no interest in making certain that the marketing is accurate, that the warnings that are given for dangerous drugs are accurate, and that's a pretty difficult thing to do. No, you have to get over that hurdle.
It's not no interest. It's no substantial interest.
That's right. No substantial
means something. Substantial means exactly what it sounds like. Something really meaningful that says in this setting and this setting alone, New Jersey law will trump. And I'll come to why that's not true. But to answer the other part of Your Honor's question, the reason our view is section 142 doesn't lead to a different outcome, but it is certainly a different analysis. And section 142 itself tells us right away that's not what's intended by this section. Comment B to section 142 says, this embodies the recommendation of this section to give statutes of limitation the same analysis as other substantive choice of law issues. Comment E, the rationale refers to the modern trend under which the courts select the state whose law will be applied to the issue of limitations by a process essentially similar to that used in the case of other issues.
But it still puts the presumption here, and it makes a big difference. Where the presumption is for lex loci statute of limitations is big difference, because if the interests are in equipoise, if you got down to the second part of 142, then it's the forum state for statute of limitations, and the opposite would be for the for the substantive law of the state applying Camp JC.
To the extent it makes any difference, Justice Hoffman, and we don't think it ultimately makes a difference here, but to the extent it makes any difference, section 142, comment B, comment E, comment G, they all tell us that's not what this section is intended to do. This court's jurisprudence, from Heavner to Cornett, tells us that's not what this court's jurisprudence intends for statutes of limitation to be treated differently.
So why should your company complain when the plaintiff comes to your state where you manufactured the product, where you're incorporated, where you marketed the product, where you drafted what they're claiming are the inadequate warnings to the product? Why should you complain about forum shopping under those circumstances?
The complaint is not with the suit being brought here. The complaint is with the attempt to pick and choose the law that applies here. Petitioner almost said suit was brought here because the statute of limitations is better here. What the petitioner did, though, was the petitioner said, I don't like New Jersey substantive law. I don't like it. I don't like the PLA. I don't like the measure of deterrence that the PLA sets in this context of FDA-approved drugs. So I'm going to disregard those and say the contacts favor my own state's law on every issue, but the one issue that would bar my claim. And on that one issue, even though we know what New Jersey's deterrence interest is, it's the PLA.
Well,
it's a lesser deterrence interest on that one. I'm sorry, Your Honor.
Okay. I know that you're saying the Product Liability Act has this obviously presumption if there's FDA approval. But Wyeth versus Levine has spoken about the state's interest, its corollary interest in ensuring that pharmaceutical companies properly give warnings. Correct? So you can't say that the federal government has a singular interest when the U.S. Supreme Court has said that we have a concomitant interest in ensuring that there are adequate warnings. No?
The PLA is not based on saying we are going to abdicate all responsibility to the U.S. government. It's not a preemption statute. It's a statement of New Jersey's interest. It's a statement of, in this setting, the New Jersey legislature, repeatedly affirmed by this court in Roe, in Perez.
So you got the benefit of that at the trial. You got the at the trial of this case.
No, we did not, and that's the problem we have, is that on every other merits affecting issue, the plaintiff said, we don't like New Jersey law. It doesn't apply, but there's something special about the statute of limitations that does apply. That's our concern with, maybe it's better described as law shopping, but that's our concern with what happened here. There's not a rational system where you can say New Jersey's interests say they're not strong enough to actually apply New Jersey's articulated deterrence interest as expressed in the PLA.
So you like sections 145 and 146 of the restatement. You just don't like section 142 because it places a presumption in a different place.
We don't think it's consistent with New Jersey precedent. We don't think in this setting, in a personal injury case, it's even consistent with the restatement itself because of what the comments to 142
Can you
tell us,
walk us through the analysis under 145 with a focus on the issue that we're considering, which is the statute of limitations, not the broader issues
Yes.
of choice of law, but the specific issue that is being carved out for application based on New Jersey law?
Yes, Your Honor. Justice Levicki, I think that the answer to that question is to look at the contacts and at the relevant interest. In terms of the contacts,
The place of injury you conceded is Alabama.
yes.
How about the place where the conduct causing the injury occurred?
Place where the conduct causing the injury occurred, the most relevant place, that was multiple jurisdictions, but the most relevant place was Alabama, because that's the place where the warning was given to the doctor. That's the place where the doctor, in turn, discussed the medication with the patient.
And those are the facts that should be considered in considering that factor for SOL purposes.
Yes, Your Honor.
Okay.
And it's interesting, if you look specifically at the statute of limitations, the relevant question under New Jersey law in terms of the statute of limitations is what did the plaintiff know, when did they know it, what could they have known?
When
Those
should they
facts
have
all
known
took
it?
place in Alabama.
It would seem to, when you're talking about the doctor gave these instructions and that, I can see that pertaining to an action against the doctor. But the plaintiff here is claiming that the wrong occurred in New Jersey because this is where the marketing decisions were made and where the inadequate warnings were crafted. And I guess if you fired a gun from New Jersey and it struck someone in Pennsylvania, I guess the place of injury is Pennsylvania. But what about shooting the gun from New Jersey? That's not.
Well, this is a little.
Is that a wrong? And that's what I think that they haven't said it that way, but they're claiming that the gun was fired from New Jersey and it struck the victim in Alabama.
I don't think they can say it that way, Your Honor. And the reason they can't say it that way is because the essence of their claim is a failure to warn Dr. Gerald in Alabama and the impact that that failure to warn had on a patient in Alabama. The relationship from the plaintiff's perspective was centered in Alabama. That's where Dr. Gerald read the warning. That's where the warning was or was not passed along to the patient.
But they're claiming that the warning was inadequate. So they're, I guess they're arguing that the doctor was misinformed, that the doctor was passing along the inadequate warnings that he was given, he gave to the patient. That's their argument, no?
That is their argument, but that conduct occurred in Alabama. That's where the warning was read. That's where the warning was heeded or not heeded. That's where the warning was followed. That's where it was taken into account in the prescribing decision. And that's where That would be true in any warnings cases, particularly true in a prescription pharmaceutical product case where you have to have that intermediary, and you then have the patient as a further step only in Alabama. So I've addressed, I hope, the lack of a substantial interest because of the PLA. And the one further thing I'd like to say on that, given how much Gantes has been discussed, is that Gantes actually anticipated this very situation. Gantes...
Are you done going through the factors in Section 145?
I'm happy to address the factors.
Why don't you touch on the last two to finish
Sure.
the question?
Is the Chief asking about predictability and uniformity?
Those are
Domicile?
Section 6. We were down to the last two factors in Section 145, domicile, residence, place of incorporation, business of the parties, it's third, and place where the relationship, if any, between the parties is centered.
Well, clearly the relationship is centered in Alabama, and that's what multiple pharmaceutical cases, including the Cornett decision, have recognized. Clearly the relationship was centered in Alabama. The place of incorporation and place of the parties is split between New Jersey and Alabama. You have the doctor and the patient in Alabama. From the patient's point of view, there's no presumptive knowledge that they're using a prescription medicine made by a New Jersey company as opposed to a Boston or a San Francisco company, but Roche is incorporated in New Jersey. So going through the factors, and this is why at plaintiff's urging, these factors, these contacts favored Alabama on everything else. Going through the factors, they favor Alabama just as equally on statute of limitations. The point I was going to make about Gantes is Gantes anticipated a PLA case being different. Gantes has a sentence in the decision where the court says, "It is significant that New Jersey's statute of limitations does not single out manufacturers or distributors of manufactured products as a class meriting special protection from personal injury tort actions." This case is different because the PLA does that, and this court recognized that in Roe. The court recognized in Roe that the PLA, at least the pharmaceutical super presumption, as this court has referred to it in the PLA, does single out manufacturers of pharmaceutical products, in the words of Gantes, as a class meriting special protection from personal injury tort actions. And then this court in Kendall applied that reasoning even in the statute of limitations context, referencing the legislative desire to lessen a drug manufacturer's potential liability for using an FDA-sanctioned warning, and holding that that would also extend to protecting that same manufacturer from an open-ended burden of defending belatedly filed product suits. So we know from Gantes, it anticipated that there might be different circumstances with something like the PLA.
So
Roe tells us the PLA.
Did Gantes also say this, tell me if I'm mistaken, the state whose law determines whether an action is time barred is not necessarily the same state whose substantive law would apply if the action is maintainable?
Yes, it did say that. I assume it said that. I assume Your Honor was reading.
Well, I'm actually reading from Pitcock, so
Okay.
which is citing to Gantes,
I assume
which is making the distinction between the application of substantive law and the statute of limitations.
I think what Gantes is doing instead, Your Honor, is saying that it's an issue-by-issue analysis, but the issue-by-issue analysis shouldn't be applied in a way that just doesn't make sense. And the second reason that I wanted to say that it doesn't make sense here, that there's no substantial interest here, aside from the PLA, is that the discovery rule and the statute of limitations is not about deterrence, which is the only substantial interest that's been offered by the petitioner. It's about finality for defendants. The court recognized that in Cornett, going all the way back to the seminal discovery rule decision in Lopez versus Swire. The court recognized that. After all, statutes of limitation are statutes of repose, and the principal consideration underlying their enactment is one of fairness to the defendant. That's what they're about. The argument here is not, we know statutes of limitation are intended to deter. This should deter. The argument here is you have a tool that is intended to promote finality, that recognizes that there's an inherent prejudice to
So I think
defendants.
if the purpose of statute of limitations is to ensure that there aren't stale claims, and your company is in its own state, and the claim is not stale under our law, like, what's your complaint?
The complaint, well, I would say a couple things to that, Justice
Right.
Albany. The complaint is the picking and choosing of the law, picking the one aspect of the law that allows the claim to proceed and ignoring every other aspect of New Jersey law. The argument has been made that that would somehow promote certainty. That would be an argument for applying New Jersey law across
So
the board.
people do that. I mean, look, you can go to a state because procedurally the statute of limitations and all of the court rules will apply, correct? We don't say that something's evil about that because New Jersey is going to apply its rules of evidence and its court procedures, right?
40 years ago, this court said the statute of limitations is not procedural. 40 years ago, it led the nation in rejecting that very rule and saying that statutes of limitations should be treated the same as
And the
everything else.
restatement doesn't say it's strictly procedural, but it takes into consideration its historical development, and therefore it gives there's a starting point, the presumption.
That's why it doesn't make sense in this context where it leads to a different analysis. But even if it applies, I do want to emphasize this point, even if it applies, it doesn't make sense to say there's a substantial interest in New Jersey statute of limitations from a deterrence perspective, because that's not what statutes of limitation are about. And in that regard, the Gantes case is very, very different from this case. Gantes was a case that was literally barred the moment the injury occurred because of how the statute of repose worked in that case. In this case, what we have is a difference between Alabama and New Jersey in terms of how the statute is calculated. Both states gave a meaningful period of time from after the petitioner was warned that Accutane may cause rectal bleeding, diarrhea, severe abdominal pain, after his doctor was warned about inflammatory bowel disease, after he experienced those symptoms, after he was told that he had inflammatory bowel disease. Alabama's statute gave a meaningful amount of time for him to sue after that point in time. New Jersey gives a longer period of time, subject to a case-specific, case-by-case discovery rule analysis, which right away argues against any uniformity from applying New Jersey law, when we've already seen in this mass tort multiple discovery rule hearings going both directions. That's not uniformity, that's not predictability. That's very different where you're talking about how long the limitations period is from the Gantes fact pattern, where there was literally never a claim on the day the claim arose.
Can you clarify one aspect of your 145 analysis? You
Yes,
said
sir.
with respect to conduct, that favors Alabama. How does the conduct of Hoffman LaRoche favor Alabama law?
The conduct of
Of this
Hoffman,
defendant favor Alabama law?
the conduct of Hoffman LaRoche occurred in a number of jurisdictions. Some of it occurred overseas. The plaintiff spent a lot of time talking about
So
overseas
you're
documents.
basing that on where the particular warning is read to the injured plaintiff rather than the conduct of Hoffman LaRoche in deciding on and publishing the warning?
Yes, Your Honor. There was absolutely meaningful conduct from Roche in New Jersey, but that conduct came to rest in Alabama.
And that, to your mind, is the controlling aspect of the conduct that favors Alabama?
Yes, and coupled with that being the place where the relationship was centered, that's the meaningful place for the course of law analysis.
The consideration of Hoffman LaRoche's manufacture of the product, distribution of the product, development of the warning, publication of the warning is irrelevant to that consideration?
No.
It's overridden by the ultimate reading of the warning.
Yes, that's exactly my argument.
That's the
Your Honor.
conduct. So following up on Justice Solomon's point, the conduct that you're attributing to Roche is the conduct of the doctor. And the conduct of Hoffman LaRoche was all the things that Justice Solomon just pointed out.
But it resulted in not the conduct of the doctor, but the
He
warning.
may have been injured in Alabama, but it was a result of Hoffman LaRoche's conduct in this state. He did everything here. Manufactured the product, manufactured the warnings. All that occurred here and was distributed from here. No?
That occurred here and in various other jurisdictions, but it came to rest in Alabama.
Not this
That's-
product. This product was manufactured here, not in various other
This product was-
jurisdictions.
Yes, Justice, this product
It's
was
easy for you to
manufactured here, but the conduct that was challenged in the trial was here, it was in Switzerland, it was in other jurisdictions. I'm not arguing with the point that meaningful conduct occurred in New Jersey. It absolutely occurred in New Jersey. My point is, I think, what you said at the end, Justice Solomon, which is that when the relevant contact is where that conduct came to rest. That conduct came to rest where the warning was provided to the doctor, not where the doctor provided the warning. That's an independent contact that's relevant, but where the warning was provided.
Why is that more substantial? Why is a doctor following the guidance that he has been given by the defendant company more important than the guidance itself?
Because that's the nature of the wrong. The nature of the wrong is a failure to warn the doctor in a way that the patient claims impacted their use of the medicine. That's the claimed wrong, a failure to warn the doctor. The failure to warn the doctor in their allegation occurred in Alabama.
But wasn't the doctor simply a conduit?
No, the learned intermediary doctrine recognizes in both Alabama and New Jersey that the doctor has an incredibly meaningful role in the case. The patient literally could not get this medication without seeing a doctor. That's the basic premise of the learned intermediary doctrine.
But the information that he's giving is information that you provided to the doctor to give to the patient. And
Yes.
I think that's what the plaintiffs are saying is the issue here.
Yes, that's exactly right. But our point is that information the doctor actually draws on, and the law recognizes that there must be accounting for other information that the doctor has in their medical experience that they draw on. The doctor here had other experience that guided her decision to prescribe Accutane. But my point is simply the warning was given in Alabama. The doctor was integral to the patient getting the medication. That doctor was in Alabama, received the warning in Alabama, and then counseled the patient in Alabama. I'm not disputing that there are important New Jersey contacts in this case. They just don't outweigh the Alabama contacts without some kind of material, in the words of Section 142, substantial New Jersey interest. And just as plaintiffs argued that it didn't exist on any other issue, it didn't exist on the statute of limitations because of the PLA and because of the discovery rule. And I'll close by...
May I ask a follow-up? Is there any suggestion that the doctor did anything other than follow the guidance from the defendant corporation?
Well,
and wouldn't that make for a stronger case if it had happened?
That's a hard question to answer, Chief Justice, because I guess it depends on what Your Honor means by that question. There was evidence in the record that the doctor relied on her prescribing experience and what she had seen in her prescribing experience, and that obviously is independent of the warning provided. There's also the fact that we provided an explicit warning, a prominent warning about inflammatory bowel disease, and she didn't pass along a warning about that term, inflammatory bowel disease. I believe she asked about a history of gastrointestinal problems in Mr. McCarrell's case, and that was all. So,
is the doctor a party to the suit?
The doctor has...
You haven't brought the doctor in?
No, the doctor has never been made a party to this lawsuit. The plaintiff has not faulted the doctor. We have not brought the doctor into the lawsuit. If I may close, the point I would like to close on is both looking at what the law tells us and looking at the result that we saw in this case and how petitioner's rule would, in our view, create a kind of Frankenstein's monster of choice of law rulings that are logically inconsistent with each other. In terms of the law, that's contrary to what New Jersey law tells us. Huebner says statutes of limitation are analyzed the same way as other issues. Cornett tells us that means it's appropriate to apply 146 in this setting, and 146 on these facts calls for injury state law. Gantes did recognize a deterrence interest on very dissimilar facts, but Gantes said that interest might not apply in a setting like this. And then Roe confirmed that it doesn't apply in a setting like this. It doesn't apply when a plaintiff is barred in their home state and seeks to come to New Jersey. In the words of Roe, this state's interest in ensuring that our corporations are deterred from producing unsafe products, which was determinative in Gantes and however weighty in other contexts, is not paramount. Kendall tells us the PLA has force even in the statute of limitations context, further diminishing any deterrence interest. And then Cornett, in cases as far back as Lopez, tell us statutes of limitation are not tools of deterrence. They're intended to protect defendants. All of that points to Alabama law, but the point I want to close on, the appeal I want to make to the court, is a much more common sense point, which is we know we have a statute here that has been repeatedly recognized by this court, called a super presumption by this court, that says this is what New Jersey's deterrence interest is in the context of FDA-approved medicines, and it's a lesser deterrence interest than exists in other individual cases. It makes no sense to say that deterrence interest is wholly irrelevant in this case, as the trial court did, wholly irrelevant. It has no force in this case, but somehow there's an antithetical deterrence interest that becomes controlling, that is expressed in New Jersey statute of limitations, even though that's not what statutes of limitation are about. That's ultimately our appeal to the court, is that we're right on the law under the principles that I went through just now, but in terms of logical coherence and common sense, it doesn't make sense to say we're going to disregard New Jersey's deterrence interest where it's articulated, where it exists, but instead vest it in a tool, the statute of limitations, that was never intended to provide deterrence.
And is the sum total of that wrap-up that you just provided us why it makes sense for us to stick with a 145, 146 analysis and not adopt 142?
I think it's both, Justice LaVecchia. It's why it makes sense to stick with 146. It's why there's no substantial interest even under 142.
Thank you.
Thank you very much.
Good morning. We ask that this court adopt sections 145 and 146 of the restatement as it relates to choice of law on the statute of limitations. In Hoffman, this court effectively applied the presumption that we find in 146. In Hoffman, this court went through an analysis that we now find in sections 145 and section 6 of the restatement. And in reaching its result, this court in Hoffman reasoned that it made sense that we would apply the same state's law to the question of whether the plaintiff has an original right to bring the lawsuit, and by original right, can he or she file it at all because of the statute of limitations. We'd apply the same state law that we would to whether the plaintiff can maintain the cause of action. And by maintain the cause of action, I mean, does the plaintiff have the elements for a product liability case under the substantive law? What's not in Hoffman, but is in Kendall versus Roche, is you can't separate the statute of limitations state law from the substantive law because they interact. And that's Kendall. Kendall was a statute of limitations case, and in Kendall, this court looked over to the substantive law and looked to the Product Liability Act to reach its holding on the statute of limitations. Deterrence, different subject. The most recent decisions of this court are clear that deterrence is not a factor on the statute of limitations. In PV, this court said we're going to do a choice of law issue by issue. And it said something else. It said on each individual issue, we're going to look at the factors that are relevant to that issue. Here the issue is the statute of limitations. And in Cornett and in Kendall, this court said the reason we have the statute of limitations is first, to give plaintiffs an incentive to file timely, and second, to protect defendants from stale claims. There's nothing in either Cornett or in Kendall about deterrence, the two most recent statute of limitations cases. Nothing in those cases. In fact, in Kendall, the court said the considerations on the statute of limitations when we develop a rule of law are as follows. On the one hand, fairness to a plaintiff who may not know that she has a cause of action. And on the other hand, fairness to a defendant with respect to defending against stale claims. Finally, all of the policy reasons that were in Hoffman for the holding of Hoffman apply here. Let me remind the court of what I think is a critical factor. Heavner was one plaintiff. We have pending in New Jersey 15 multi-county litigations. About 13 or 14 of them are against New Jersey-based pharmaceutical and medical device companies. The overwhelming number of the MCLs are populated by non-New Jersey residents. If we, in fact, give a plaintiff a strategic reason to come to New Jersey, we will see increased filing here. And I would submit with some confidence that given the budget conditions that this state sees, and they're going to get worse in my view, adding plaintiffs to our MCL docket is going to be a strain on this court's budget. I would also state that adding non-New Jersey plaintiffs delays New Jersey residents from getting to resolution of their cases, not only within the MCL, but within those three vicinages where the MCLs are present. Just to toss out a number, and you're probably more familiar with than I, Atlantic County has 4 MCLs. Accutane's the largest at 1.8 thousand plaintiffs. In the last 2 years, according to the AOL statistics, there were 10,000 lawsuits, civil lawsuits filed in Essex County, putting aside equity and putting aside special civil. One judge with his one law clerk in Atlantic County has at 1.8 thousand of these cases. And finally, allowing plaintiffs in this situation to make the strategic decision when they're barred in their home state to come to New Jersey and file the lawsuit has a negative impact not only on our largest industry and our largest employer, but the companies that make the most important products sold in the United States, medicines and medical devices, which save lives and better lives for people who are ill. So for all of these reasons, we ask that this court adopt sections 145 and 146 of the restatement, and that it not adopt section 142.
So do you, I take it you've done what you're...
I am, thank you.
So do you want to bar out-of-state claims in New Jersey?
Absolutely.
You want to build a wall?
Well, absolutely.
So all of your statistics, I don't know what percentage of, those are people who are coming to this state seeking justice against a defendant who happens to reside here, manufacture products here, and issue warnings from here. And all the statistics that you were giving were suggesting that we should somehow build a wall and not permit plaintiffs to be coming into the state to file suit against the defendant.
I'm not taking that position at all.
Then what was the purpose of all the statistics?
Because now we're talking about an additional group of plaintiffs who would be barred in their home state coming here and adding to the docket.
Well, they would be coming here to file a suit where this state is under its own statute of limitations, says it's not a stale claim. You're saying it's a stale claim, but not under our law. It's not a stale claim, is it?
No, it would not be a stale claim under our law.
Okay, so?
But that overlooks Alabama's interest in regulating its own citizens. And what I mean by that, the Alabama courts have said that there are 2 purposes to the Alabama statute of limitations. One purpose is to give defendants protection against stale claims. The other purpose is to regulate Alabama citizens.
But Alabama would be happy to have one of its citizens vindicate its claim in a New Jersey court. You're not
If that were the
suggesting...
case, they would change their statute of limitations to allow that in their state, wouldn't they?
That's what I'm saying. Alabama has no interest in let me finish this.
Go ahead.
Alabama has no interest in compensating Mr. McCarrell. If Mr. McCarrell filed a lawsuit in Alabama, the Alabama Supreme Court would readily apply the Alabama statute of limitations, and he would be barred there. Alabama has no interest in deterrence, and more importantly, no interest in compensating Mr. McCarrell. So I'm curious why, and this is a rhetorical question because I know I don't pose questions, the court poses, but I'm curious why we would have an interest in compensating Mr. McCarrell from Alabama when the Alabama courts and the Alabama legislature would say they have no interest in compensating him. It seems to me under comity, which is one of the things that runs through our choice of law of jurisprudence, if Alabama has no interest in compensating him, we wouldn't have an interest.
Well, you don't think that New Jersey would have an interest in permitting a citizen of another state to seek compensation from a New Jersey corporation that has wronged that person?
Not when that citizen in his own state, as Mr. McCarrell would be barred, and the defendant would get summary judgment in that state. I'm sorry, Justice Sullivan.
I didn't mean to interrupt you. I'm trying to jump into a
Go ahead.
pause for a second. I thought you were talking about a kind of an administration of justice analysis, that we'd be burdening our courts, we'd be delaying rights or access to our courts because of the number of cases that might be filed here. And I think that's the argument you were making.
Well, that's a policy argument.
A policy, okay. As to that argument, we heard from plaintiffs that many states, maybe most states, have a more liberal statute of limitations or broader, longer statute of limitations than New Jersey. Do you disagree with that?
I don't know the answer to it because I do not know all 50 states' statute of limitations, Justice Solomon. If you wanted, we could supplement on that and send a letter just answering
I don't
that
think
one.
we need that. Our clerks can figure that out. But also, Mr. Schmidt said that New Jersey, for the purpose of demonstrating liability under the Products Liability Act, for that purpose, New Jersey's standard is lesser for defendants, and therefore, isn't it likely that it would diminish if plaintiffs write about the statute's limitations and Mr. Schmidt's write about the standards under the Products Liability Act? Wouldn't that tend to lessen the number of claims, particularly multi-district claims, that are brought in New Jersey and in fact enhance or argue in favor of New Jersey in terms of administration of justice?
Let me give a little bit of a long answer to that.
Please
Justice
don't.
Solomon.
No, I'm just kidding. Go ahead. Make it a short answer because I'm not going to lose you.
In this case, and in most of the MCLs, the substantive law that is applied is not New Jersey law. The plaintiffs in this case asked for Alabama law precisely because the reason New Jersey law was unfavorable to them. So it's not a situation where we're going to apply New Jersey law to both the substantive and the statute of limitations. This is the worst and most unfair result because the plaintiffs are saying, and this is what they're saying, on the substantive law, don't apply New Jersey law because that's good for the corporate defendant. But on the statute of limitations, they're applying New Jersey law because that's better for us. So
I get you, and
Okay.
I understand what Mr. Schmidt was saying, but I'm just trying to figure out where that tension ends up, whether New Jersey ends up being a more hospitable state because of the Products Liability Act, or, a less hospitable state because of the Products Liability Act, and a more hospitable state, or less hospitable state, because of statute of limitations, and maybe the argument about the administration of justice doesn't militate in your favor.
Well, if we applied, and you could have a rule, I'm going to talk broadly, you could have a rule that for an ease of administration, we're going to apply New Jersey substantive law and the New Jersey statute of limitations. That would be much easier on the trial judges. They know New Jersey law, then they don't have to look at the other states. And in fact, that would be a departure from Camp JC. That would be a significant departure, but this court's done that before. In asbestos, for instance, Bashada, the court said there was no state-of-the-art defense, limited to one kind of case, one mass tort. I don't know whether the court got that as a matter of common law or under Winbury. Then in Feldman and later cases, the court said that's only for asbestos. So it would be a rational decision. Indeed, you could say if the plaintiff chooses to come to New Jersey to sue, he or she can't complain about New Jersey law. Roche is here. Therefore, Roche can't complain about New Jersey law. That would be a logical way to do it. You can't do it in this case because that would be wholly unfair to Roche. You can do it prospectively. The reason it would be wholly unfair to Roche, unless you remand it to the trial court for plenary proceedings, is Roche has already gotten the bad Alabama law, the less favorable Alabama law.
Well, this goes back to something Justice Holmes said, that like a page of history will tell you more than a volume of logic. So, we in order to understand what's going on here, you really have to understand the historical distinctions that have been made between substantive law and procedural law. We apply our evidence rules and our court rules, and that attracts plaintiffs here. They like our evidence rules, they like our expert witness rules, and we apply it. We don't apply the evidence rules of another state. And the statute of limitations has been in this sort of like netherworld. In the common law, it was considered procedural. Then in Hebner, we said we weren't going to follow it. But the restatement is giving some traction to its historical basis. And therefore, it's set, and that's why the presumption is set there. And it's the reason why the presumption is set with lex loci. So it's understanding the way these principles have developed over hundreds of years, that where we're at now. It's the reason why the drafters of the restatement have drafted these rules the way they've done it.
Well, I think that train left the station 43 years ago in Hebner, where the court said, statute of limitations had been procedural, and they cited and quoted all of the academics at that time why that was a bad rule.
But things change. Look, until we got the Camp JC, we hadn't adopted 145, 146. We had a governmental interest. The law is evolving. We've decided to go the restatement route. And the question is, now that we've gotten on that train, why won't we go along with 142 and make it all of a piece?
And I'll just incorporate what I said before. For all the reasons I've said up to this point, Justice Elman, I have nothing more to add to that. It would be wholly unfair to subject a New Jersey company to the New Jersey statute of limitations, unfavorable to the company, and then to say we're going to have a different rule for the substantive law, and we're going to let the plaintiff pick and choose and have Alabama law there. Normally, in the administration of justice, what we're worried about, corporate defendants are worried about, is some local state court treating the corporate defendant badly because they're an out-of-state corporation. If we look at this record in this case, Roche, a New Jersey defendant, would end up with a worse result, if you adopt the plaintiff's view, in the New Jersey state court than it would in the Alabama state court. Roche would actually get a better result had they been sued in Alabama than they are if you adopt petitioner's view of the law. And that just can't be. And I'm not looking for special treatment for Roche or any of the corporate defendants. I'm just looking for equal treatment.
You're saying that New Jersey substantive law should apply here?
Well, I haven't...
That's not an issue before us anyway.
That's not an issue before you, but if you decide to do that for administrative ease, and as I said, there's a lot of logic to that, I don't think you can do that in this case with a $25 million verdict against Roche without either making it prospective or sending it back to the trial judge and say, do over, do everything under New Jersey law.
Do you know about how many jurisdictions have followed the approach you're suggesting?
I do not, Your Honor.
Any other questions?
Chief Justice, I just wanted to thank the court. The court's been liberal at granting not only the New Jersey Civil Justice Institute, but the other business organizations, liberal in granting leave to appear as amicus, and we thank the court for that.
Thank you. Mr. Buchanan, did you want to offer a brief rebuttal?
I'll try and be as efficient as I can. I have a few points I'd like to clarify. There's a suggestion that there's been this kind of whipsaw happening with regard to Roche as it relates to New Jersey law versus other law, and the inability to satisfy New Jersey law with respect to his claim. The appellate division in McCarrell 1, it's an unpublished decision, but the appellate division in McCarrell 1 found that the proofs presented at trial satisfied both Alabama substantive law and the New Jersey rebuttable presumption. That's not the only case where that finding existed. That was rendered by the appellate division in Kendall 1, and the Supreme Court observed as much with regard to the PLA in the statute of limitations context in Kendall, which it rendered in 2012. Just 2 months ago, the appellate division rendered a decision for a New Jersey plaintiff and recognized that the proofs elicited at trial satisfied the rebuttable presumption once again. So this is not a situation where the proofs do not satisfy the rebuttable presumption. The reason why Alabama substantive law is being applied is because that's what our choice of law jurisprudence directs.
So can you respond directly to the law shopping argument we've heard from counsel and from amicus?
I don't accept that there's law shopping. I mean, there is certainly advocacy, and for our clients, we try and obtain a jurisdiction that we think will best serve the needs of the case. Sometimes that's because everybody's amenable to service and discovery and process and potentially appearance at trial. Some courts, like Delaware in corporate land, or New Jersey perhaps in pharmaceutical, where this court's been in the vanguard of pharmaceutical litigation, have experience with pharmaceutical cases, have experience with the jurisprudence. If you take some of these issues to other courts, they are very novel. And there's not a rich jurisprudence in those courts, and there can be a lot of spinning of wheels, as in some respects, unfortunately for 13 years, on statute of limitations for Mr. McCarrell, where there is some lack of clarity now, seemingly as to the standard. So yes, there are reasons to come to New Jersey just for clarity, because I can assure you, the rules are not always good, and they're not always bad, and it's probably some issues they like, some things we're happy about, but on balance, we hope that we know what the landscape is. And that's, I don't think that's forum shopping. That's trying to understand the road before you go down the road.
But who was arguing for the application of Alabama substantive law, and who was arguing for New Jersey substantive law below?
I think it was recognized initially by the trial court under her choice of law jurisprudence as thinking that it had to be substantive law. But candidly, Your Honor, that was 9 years ago. The case was initially filed under New Jersey law. I think it was pled under the New Jersey Products Liability Act, and at some point in time, and it was in the pretrial phase, I believe, it was amended either formally or informally to conform to Alabama law.
Isn't it also true that in filing this products liability action, virtually all of the discovery, which is, in products cases, is pretty overwhelming, is going to be here in New Jersey for the plaintiff and the defendant?
Generally it is, and when you see New Jersey defendants, often we'll be in a conference room in Morristown taking depositions, or we'll be in a conference room in Newark taking depositions, as happened quite often in this case many years ago.
Is that somewhat evidence that there was not forum shopping in this case? The fact that plaintiffs did what, and frankly defendants did, what was convenient for them from a litigation standpoint?
There's no doubt. I mean, to do a case like this without cooperation from the courts, without the cooperation of co-counsel, doesn't work. I mean, frankly, these are well-resourced defendants. They litigate vigorously, as the last 13 years tell in this case. They have the ability, and we have the ability when we are able to litigate together and meet them on an important issue in an important case. That happens in New Jersey, and Mr. Cott highlighted 15 cases. There's many in Boston. Boston may be a larger pharmaceutical hub than New Jersey. You can go to California and Illinois. I would note, Massachusetts recognizes 142 for its statute of limitations principles. Illinois, another hub for the pharmaceutical industry. I think it's the third or fourth largest. They recognize their statute of limitations as procedural. So that if you file in there, if I'm a New Jersey person, I get the benefit of their statute of limitations. For better or for worse, whether it's good for New Jersey or bad for New Jersey, you know the rules, that's what you buy, that's what's happening.
Do both of those states have tolling provisions?
I know Illinois does, and Massachusetts does as well. I think they're longer statutes of limitations.
Mm-hmm.
And they've
Your Honor,
embraced, have they embraced 145, 146 as well?
Certainly. Mr. Schmidt went through the contacts, and we start with 145 and we look at context, where the party's from, where the conduct happened, where is the relationship centered, and there's a clause in there, if any, between the parties. This is an interesting case. I mean, the restatement is not really written, it doesn't seem like, in a product manufacturing framework where there could be very substantial conduct in one place, the bullet, the trigger being pulled, crossing the river and hitting somebody on the other side. I don't know that the relationship is centered anywhere because, frankly, Mr. McCarrell never really did business with Roche. Mr. McCarrell went to his doctor and he got a prescription and he filled it. Roche never really knew Mr. McCarrell. It was up the food chain or the distribution chain and sold something into him. But there's massive conduct, obviously, in New Jersey that's relevant to the liability aspects of the case. And there's also issues that are relevant, obviously, locally with regard to where Mr. McCarrell is. But I don't think there's really a center of the relationship in the traditional way that the restatement's talking about. They're talking about somebody getting into a car with a friend and driving over the border, hopping on a train.
That's the nature of a suggestion in the restatement itself. It's trying to cover a broad swath of ground.
Indeed, and frankly, I don't think it changes the analysis if the if any is, well, you know what, it's a push. Essentially, there's relevant conduct here and there's relevant conduct there. Because you're supposed to step back under 145 and 146 and then double back to, Section 6 and see how are these contacts germane to the issue that you're analyzing. When you double back, and it does say to the issue, not just general litigation, it's to the issue that's being analyzed. Here's statute of limitations. Notably, Alabama really doesn't have an interest that comes into play here in New Jersey. We cited the cases in our brief, in our supplemental submission. There's the Trexon case from '79. There's the most recent Precision Gear case from Alabama, both Alabama Supreme Court, recognizing that for them, it's procedural. If you file in there, you're getting Alabama procedural law. There's no choice of law analysis around statute of limitations in Alabama.
Counsel, I find it difficult to think of statute of limitations as procedural when we've developed an extraordinary amount of case law trying to figure out when a case accrued, let alone when somebody should have discovered it. I mean, that has become a cottage industry, if you will, in terms of understanding that law.
Those are indeed thorny issues, and probably we lament the simplicity of substance versus procedure. But
right.
There were injustices under that framework, which is why I think we've evolved to the more modern framework.
I mean, even our wrongful death statute has now been allowed for discovery, even though you certainly know when a date of death is, correct?
Indeed. Indeed. And to highlight the thinking, though, of the Alabama Supreme Court and how clear it is that while we can't take your case for an Alabama resident, we have no fault with you going elsewhere to a court who has an amenable statute of limitations. Judicially, they have not created a discovery rule. Legislatively, it was the statute was struck down for some component of it, so the whole statute dropped, and it was never reintegrated. But here's the quote from Textron. But such a bar under the statute of limitations in Alabama should not bar Whitfield's substantive claim elsewhere. We are of the opinion that the plaintiff can present his claim elsewhere in a jurisdiction which has a longer or different statute of limitations and prevail on the merits of his claim. He should not be barred from that opportunity. This is from an interest perspective, because if we're looking at New Jersey's interest, and there was a discussion about a deterrence interest, there's also the discussion, and I was pleased to hear Mr. Cott recognize it, under Lopez. That is the conflict here. We're talking about New Jersey recognizing a discovery rule where Alabama does not. If we go back to Lopez, we go to Kendall, we see the recognition that that is indeed something that's very important to New Jersey. The recognition that a claim should not be barred in somebody simply because they didn't know. That's a New Jersey policy of having cases decided on the merits. That is beyond the deterrence interest that counsel seems to be distancing themselves from, that's expressed clearly in Gantes. There is indeed this interest in having claims determined on their substance and not on a procedural bar merely because they had no idea they were hurt or had no idea they were hurt due to the wrongful acts of another. So we have, I would submit, an interest by Alabama in this situation, of having the case go forward, of having a state that has an open statute of limitations welcome its citizen because of whatever procedural bars exist, and frankly, an interest in New Jersey in promoting that, where somebody who discovered their injury on May 23rd or May of 2003 and filed 60 days later, secured counsel and filed 60 days later. There was no dilatory conduct. He acted promptly, expediently, and his claim has been determined on the merits now twice.
Anything else you'd like to present?
I did want to know one point, Your Honor, and it was with regard to the Product Liability Act that has been highlighted. Counsel suggested that it's difficult to process the ask because I think the ask is, we're from New Jersey, give us a break. Hey, I'm from New Jersey, and I have a problem with, I'm from New Jersey, give us a break. If I get hurt, or if my child gets hurt by a drug made by somebody in Massachusetts, I really hope that that's not an argument that carries sway someplace. That is a scary proposition. If there is New Jersey-based conduct, we hold our companies accountable. That's what Ganti said. The deterrence interest is significant. The PLA strikes a balance. The PLA says, yes, you've got to satisfy this rebuttable presumption, but it is not, in any sense, an exculpatory provision. It sets the parameters for it, and then when you satisfy them, as we did here in McCarrell, as we did in Kendall, as we did in Rosito, there's compensation awarded to people who can show that. Thank you, Your Honor.
Thank you to all counsel for the excellent arguments. Both the parties and amici. And amici, you were so graceful in thanking us for inviting you. I will admit there is self-interest on our part in having your organizations participate in the fine way that you did. We're going to take a brief recess and be back in a few moments for State versus CH.